Let's start with liberalism and democracy. Many people in the audience feel that liberal values have never been in as much danger as they are today. They will say that to your face, and they will say behind your back, it's people like Chandrachud who did nothing to stop it, that liberalism is in danger because the Supreme Court didn't do enough. Well, now. Wait for the question. This was just the insult. Now wait for the question. The question is, the cases that are usually cited to prove this, and this has happened after your time too, is say Umar Khalid. Why should this man be in jail 5 years later with no kind of trial, with nothing? I know you've commented on it before in your time, but I don't want to mean this just as a criticism of your Chief Justiceship, though perhaps it is. I mean it as a general issue about the Supreme Court as a whole. They've again denied him bail. Can you explain what the Supreme Court's position then is, now is, or what the legal position should be?
I now speak as a citizen and not as a judge.
Absolutely.
I also begin by telling you that you can have the wisdom of hindsight, and it's easy to have the wisdom of hindsight because I've left the court. But on this particular case, let me make just the law as demystified as possible and then answer the question.
Okay.
Bail before conviction should be a matter of right, because our law is founded on one presumption, and that's the presumption of innocence. That is, every accused is presumed to be innocent until they are proved guilty at a trial. The second, pre-trial bail cannot be a form of punishment. Because if someone is in jail for, say, 5 years or 7 years as an under trial, and then is finally acquitted, how do you compensate for the lost time? Yeah. When do you deny bail to an accused? I'll give you a very simple example and then answer your question.
Okay, go ahead.
Suppose you have a serial rapist and a murderer who has been arrested on the allegation that that person has committed, say, 6 or 7 rapes and murders. There's a danger that if you let that person out into society, that person might repeat the offense. Yep. So this is a classic case where you would deny bail, where there is a danger that a person after being released on bail would commit the same offense. Second, a second exception, where a person on being released on bail wouldn't be available to face trial, that is, leave the Indian jurisdiction and escape out. That's a valid reason to deny bail. The third, a person who would tamper with evidence at the trial. If these 3 exceptions are not made out, bail has to be the rule. Now, the problem which we are facing today is this. A lot of our laws, particularly those relating to national security, have turned the law on its head by substituting the presumption of innocence with almost a presumption of guilt. Now, what does a court do when the state says national security is involved? And there I believe that the court is duty-bound to carefully scrutinize as to whether national security is involved, and second, whether the detention of the accused is proportional to the plea for national security. Otherwise, what's happening is this, is that you find people being incarcerated for numbers of years. And final point which I want to make, and which will really then put my answer in perspective, is that one of the serious problems of the criminal justice administration in India is the inability of our prosecutions to conclude trials within a reasonable period of time, which means that the prosecution is not going to be completed within, say, 1 year or 6 months or 3 years. If that is so, you have one fundamental right which is at issue. The right to life under Article 21 includes the right to a speedy trial. And even if an individual law denies the right to bail, as many of our laws do today, so the Narcotics Act does that. The Constitution is the supreme law of the land. Laws enacted by Parliament are tributaries which follow from that source. And therefore, ordinary laws must yield to the Constitution. And therefore, I'm very clear in my mind that unless the well-settled exceptions are made out in a particular case, the accused is entitled to bail.
Okay. I think that's a great argument. I don't think anyone here would disagree with that. But I have just 2 words. Umar Khalid.
Look, they've been inside for 5 years.
Yep.
I'm not criticizing my court. You can understand my hesitation in criticizing my court because I was part of the institution which I was leading just last year. Each one of these principles which I have mentioned does point to the fact that you can impose conditions to ensure that the conditions for bail are not abused, but you must necessarily take into consideration that they have the right to an expeditious trial, and if an expeditious trial is not possible under present conditions, then bail should be the rule and not the exception.
It sounds a lot to me like you're saying you would have given him bail if the case had come up now.
Well, you know, it's wrong of me to presume what I would have done if I was sitting there.
Come
You
on,
know,
answer the question. Answer the question.
You know, it's easy to sit outside the court.
Yeah.
Having said this, you know, judges, let me also be fair in the court. Judges have to look at the record of a particular case and then see what the kind of evidence there is, what kind of material there is before the court. So therefore, I think I would be, as a judge who has sat in the hot seat for 25 years, be slow to criticize merely because I have a difference of opinion on this one.
Difference of opinion, i.e. you don't agree. I think you've just given yourself away with that phrase. Yes?
I just made my point.
All right, okay. I think we've got that. But let's talk generally about bail. Umar Khalid is a celebrated example. But your court has had a mixed record. You've sometimes been very good on bail, haven't you, when you were there?
I think we have. In fact, you know, during my period of 24 months, we disposed of about 21,000 bail applications. And I must tell you that there are cases which people don't think about when they criticize the Supreme Court for not granting bail in a particular case. And I'll give you just two illustrations which come to my mind straight away. There would be probably many more. You've probably heard the name of Pawan Kheda.
Yep. The Congress spokesperson. Yeah.
Pawan Kheda said something which I believe none of us in the audience would say about some other person's parentage, be it a political leader or anybody else. He was about to be arrested. He was boarding a flight, I believe, at Guwahati, and he was about to be arrested. The paramilitary forces had surrounded his aircraft. His lawyer came and mentioned before us, soon after we assembled after lunch, that he's about to be arrested for having said something. The lawyer said that this is unforgivable. It's uncivil, but it's not a case for arrest. And we protected him against arrest. That was a leader of the opposition who had said something which was uncivil, but everything uncivil is not something which is an offense under our law. And we protected him against arrest.
And the person he'd been uncivil about was actually a very powerful person. Is it fair to say that?
Absolutely. And you know who the person was.
Yeah.
That
I
he
think
said
many
that
people
about.
will, but since he's being discreet, I won't mention the name, but think about it.
Example number two. Teesta Setalwad was denied bail by the Gujarat High Court, but they gave her time until 12 midnight on a particular day to surrender. The two judges who had heard the case differed on whether she should be granted a suspension of her sentence. One judge said she should be granted suspension of her sentence, which meant that she would get bail. The other said, no, she has to go in. The matter came up to me as Chief Justice of India when I was attending a music recital of one of my colleagues' daughter in the evening. And I said, this is a case, I was criticized for it, but I said, this is a case where she's entitled to be heard. Whether she gets bail or not is for that court to decide. We constituted a bench at 9 o'clock in the night. That bench decided, a 3-judge bench, a larger bench because 2 judges had deferred, and she was granted bail. If we had not done that, if I had not exercised my administrative powers, she would have had to surrender at 12 midnight, and which meant that she would have gone in for probably several months, or we don't know how long. So, you know, these are the kind of cases which don't necessarily see the light of the day because it's very easy to be critical of those cases where you differ with the Supreme Court. Can I give you one last example?
Yeah, sure.
You know, there was this individual. I'll tell you the name of the individual at the end. This person was charged with having committed electricity theft, theft of electricity cables and equipment. So you can imagine somebody from the margins of our society. Otherwise, who would go on the road and commit a theft of electricity poles and cables? Now, his problem was that he was held guilty in 9 cases on the same day. In each of those cases, he was granted imprisonment of 2 years. His lawyer didn't tell the court that please allow for the sentences to run concurrently, which means that all of the sentences run together. Suddenly he realized that he will be inside for 18 years for electricity theft. He went back to the Allahabad High Court. The Allahabad High Court took a legal view saying that, look, you agreed to this sentence. It was a plea bargain. How can you turn around and come back and challenge that? He came to the Supreme Court and we said, look, personal liberty is a valued fundamental right. And you can't certainly ask an individual who is guilty of this kind of an offense, to go inside for 18 years, more than what ordinarily a person would if he committed murder. Now, I'll tell you what the name of the person was. His name was Ikram. So I just thought I'd mention this because the grant of bail, the grant of relief by the Supreme Court is agnostic to faith, to caste, to gender.